What the hell?
Let's continue without Silas today. Silas, given your recent performance problems, we're reassigning your key clients.
Performance issues? No one has said anything about performance issues.
Well, this is a good time for you to reflect on your future career path.
Also, your quarterly performance bonus is suspended until further notice. You're suspending my bonus without a written warning? Let's not make this dramatic. I'm done. I don't care about the money. I'm rage quitting right now. Hit that key, and you may lose everything. They're pushing me out! I can't stay here another day! Exactly. They want you to quit so they don't have to fire you. No severance, no clean record, and maybe no unemployment benefits. Have you ever been pushed to the margins at work? Ignored, stripped of responsibilities, excluded from meetings? Or treated so badly you wanted to walk out immediately? Today, in this 8-minute masterclass, we're turning the tapes. We'll show you how to take your boss's soft violence and transform it into a documented paper trail that protects your money, your reputation, and your next move. What you're experiencing may be called quiet firing. It means the company doesn't directly say you're fired. Instead, they make the job so humiliating, unstable, or impossible that you resign on your own. So they get what they want, and I look like the one who quit. Exactly. That's the trap. In some situations, this connects to a legal concept called constructive discharge. Constructive discharge means I didn't really quit? Possibly, but pay close attention. The standard is high. Constructive discharge generally means the employer made working conditions so intolerable that a reasonable person would feel they had no real choice but to resign. But this is not automatic. You need evidence, you need timing, you need facts, and often you need to show you tried to address the issue before resigning. So if I rage quit without documentation, I might destroy my own case. Well, I don't talk. You have to hear about the juries. I might destroy my own case. Correct. The first red line is a material demotion, pay cut, or stripping away core responsibilities without a legitimate documented reason. If your title, pay, bonus eligibility, territory, clients, or core responsibilities are suddenly taken away, document it. But what if they say it's just business needs? Then you ask them to explain it in writing. Could you please confirm the business reason for this change in writing? Second red line, hostile work environment. But be careful. In employment law, this doesn't just mean your boss is rude or toxic. So a terrible manager isn't automatically illegal? Correct. A legally hostile work harassment connected to such characteristics. Don't overstate the law. Document the facts. Third red line, retaliation. That means they punished me because I complained? Complained? If you engaged in protected activity and then the company suddenly demotes you, isolates you, or targets you, that timeline matters. Quiet firing becomes powerful only when you can prove the pattern. So I don't quit today. I collect evidence. Exactly. From this moment on, you are not just a frustrated employee, you are a calm, professional field investigator. Mission: build a time-stacked paper trail. I want all your clients transferred by Friday. Also, move your desk to the storage room. You won't need to be in strategy meetings anymore. Understood. I'll follow up in writing to make sure I captured everything correctly. Sure, whatever. Confirming our conversation today. This is the as discussed email. It is calm, it is factual, it does not accuse, it forces the other side to either confirm, correct, or back away. Your memory is not enough. Build a timeline. A timeline turns isolated incidents into a pattern. And patterns are what HR, lawyers, unemployment officers, and investigators look for. Be careful. Do not send confidential company documents, client data, trade secrets to your personal inbox.
So how do I protect myself if they cut off my laptop?
Keep a lawful record of your own employment-related communications. Save non-confidential evidence where allowed. Even if HR exists to protect the company, your complaint creates a record. If the company escalates against you right after this, the timing becomes part of the evidence.
Why is he documenting everything?
Once your evidence is locked down, the game changes. You are no longer reacting emotionally, you are forcing them to think legally. If the quiet firing involves discrimination, harassment, or retaliation tied to protected activity or protected characteristics, the EEC may be one of your escalation paths. So I shouldn't file with EEC just because my boss is toxic?
Correct. EOC is not a general bad boss complaint box. If you eventually resign because the conditions truly became intolerable.
Your wording matters. What should I not say? Don't simply write, "I quit because I hate my boss." Instead, write, "I am resigning due to the hostile work environment." When you apply for unemployment benefits, the company may contest it, but a documented timeline gives you a fighting chance to show you resigned for good cause or under constructive discharge type circumstances, depending on your state's rules. No guarantee, but evidence gives you leverage.
We'd like to discuss a mutual separation package.
Please send the proposed terms in writing. I'll review them carefully. That is control. Not yelling, not collapsing, not rage quitting. Control. When dealing with workplace soft violence, don't waste your energy internalizing the stress or making impulsive moves. Turn the mistreatment into a paper trail. That is how you fight back like a professional.
Emotions alone don't carry weight in a dispute. A documented timeline, written confirmations, and formal complaints can become leverage at the negotiating table.
To help you protect yourself, I've uploaded our as discussed clarification template and the formal HR grievance script in the description below.
Use them before emotion takes over. The earlier you document, the stronger your position becomes.
Now I want to hear from you. What did your boss do to make you quit without actually saying you're fired?
What kind of quiet firing or marginalization tactics have you witnessed in corporate environments? Share your experiences in the comments below. Your story could help someone else protect their career. If you felt this video gave you the tactical edge and the legal confidence to stand your ground.
As we conclude today's legal saga, we invite you to subscribe and like our video. See you next time.